Okay, good morning, everybody. Want to thank you so much for joining us on our webinar this morning. We know how valuable your time is, and we do appreciate you joining us today. So Colony West is partnering with Outlook HR and is bringing you this webinar this morning. We will be co-presenting. My name is Evelyn Blanco. I have over 20 years of experience in the HR discipline. I am bilingual Spanish, and I also am certified by SHRM, the Society for Human Resources Management. My co-presenter is Robert Huddock from Huddock Employment Law Group. Robert has over 2 decades of experience as an attorney with over 15 years dedicated specifically to representing employers in employment law matters. So want to let you all know we have a tremendous amount of content that we will be covering today. We're going to cover as much as we can and answer as many questions as possible, as we do believe that the interactive nature of our webinars is beneficial to everybody. But again, we do have a tremendous amount of content. So if we do not get to your questions immediately, we will attempt to cover them at the end of the webinar and the time for FAQs. And if for any reason we are not able to cover them at that point, we will definitely take note and reach out to those of you individually. And again, as always, please feel free to reach out to either myself or Robert with follow-up questions so that we may be able to assist you further. So here we go. We again, ask for your patience with content. Please do stay attuned to 2 things. One, if any of the laws we talk about are in regards to your industry and your employer size, as different laws apply to different industries and employer size. Here we go. So we're talking about reopening and all of the parts, the moving parts that it's been taking as we come to hopefully the end of COVID. The topics we will be covering this morning is returning to the workplace with regards to OSHA, COVID screening and more, exclusions from the workplace, travel restrictions, reasonable accommodations, vaccination issues, and employer vaccination policy, California supplemental sick leave, hero and hazard pay, and at the end of the PowerPoint, we have put in a page of resources that you can use to help you better understand and or research anything you need. One thing I have not mentioned, as always, at the after our webinar, normally within 1 to 2 days, we will forward you the recording of the webinar, the presentation, and any other documents that are promised throughout the presentation. So Robert and I, here we go. Robert.
Yeah, good morning, everyone, and thanks for attending today. Before I get down to business, I just want to share something briefly. I was driving to my office last week and had an interesting experience. I hit some traffic on the way in, and we've experienced a lot of unprecedented things during the pandemic, and one happened here. I stopped and took note that I had a huge smile on my face as I'm hitting traffic. And that is definitely unprecedented. I am excited to get back to the workplace. I'm sure there are employees who agree with me and some that don't. But either way, we need to make sure that we are prepared for people to return to the workplace. That said, what we're dealing with here, the main topic that we're dealing with when we talk about returning to the workplace is workplace safety. Well, that's one of them anyway. And so when we talk about safety, what do we talk about, or what agency are we talking about? What standards are we talking about? And that's going to be OSHA. With respect to the entire program, I want to note this. There are multiple standards, government standards, that are applicable to the issues that we're going to be going over. Generally speaking, you have the federal level, the state level and the local level. When I talk about local level, what I mean is it's mostly counties, but in some cases it is cities. And when that is relevant, and let me back up, for the most part, there is one set of standards that you can look at, and the remaining ones pretty much follow those standards. Where it is particularly relevant, we will note today what other standards you might want to look at. So let's get to Cal OSHA. Cal OSHA has its emergency temporary standards, and those have actually been around for a while. As you can see on the slide, they were first enacted or published on November 30th of last year. Point being, there are some industries at least where people have already returned to the workplace, and these are the standards that OSHA has issued for returning to the workplace. They have been updated several times since November 30th, and they're not completely overhauled. There's just additions and certain changes, and mostly that corresponds with changes in the California tiers, for example, and the different restrictions that apply and no longer apply. The standards themselves are codified in the California Code of Regulations. The only one that's globally applicable to all employers is it's called 8 California Code of Regulations 3205. And that is a regulation which has a lot of sometimes at least complex standards. And we're going to go through some of the highlights today. One thing that is important for employers to note is the Cal OSHA has published a general summary of the most important points of the emergency temporary standards. And that's a good thing to review and keep in mind so that you have at least a foundation from which to work from. Cal OSHA also has, as every agency has throughout the pandemic, issued a series of FAQs that provide some interpretation and elaboration on the specific terms of the standards. And there on the right-hand side of the slide, we've listed there the highlights and the things that are stated on that publication by Cal OSHA, that summary publication. And you can see it for yourself if you look at that publication. And by the way, I have created for my existing clients I'll call it a guidebook, if you will, with respect to the issues that we are discussing today. And that guidebook has links to all of the documents or the guides and FAQs and those types of things in it, as well as further details regarding the subjects that we're going over today. And I'd be happy to share that with you. You can give me a call, send me an email, and I'd be happy to share that guidebook with any of you also. Can we go to the next slide?
Really quick, Robert, I wanted to mention on the must have a written COVID-19 prevention plan. This is something that I know that a lot of the people that I work with kind of vacillate on whether they want it or not, but it's very important. I can't stress enough the importance of having this because, and perhaps you can add to this, Robert, OSHA is hiring and California is hurting financially and they are out to cite. And I've had several calls and clients having citations, not prepared, barely reopening, juggling so much and feeling overwhelmed that they think this might be, not a big deal. It is in fact a big deal. And I just wanted to stress that to everybody.
I will add to that. And what I will add to that is I might as well tell you now, it's further in the slides, but there are specific terms within the regulations that say Cal OSHA will consider good faith efforts to comply with the standards. And that is another reason why I think, and Evelyn thinks, it's very important to have a model prevention program, as well as perhaps simply having some of these documents on hand, purpose being, if for some reason you get a visit by OSHA or you're contacted by OSHA, the model prevention program not only is required, but you can also show that as evidence of the fact that you are making a good faith effort to comply.
Yeah, and should any of you need assistance with this, please give me a call and I can certainly assist you with getting this completed. Anyhow, all right, moving on.
Yeah, and by the way, there is, well, you actually have to go back. Oh, no, I'm sorry, you're right. With respect, going back to, for just 1 second, to the model, the workplace prevention program, Cal OSHA has published a model workplace prevention program. It's very detailed, and by no means does every employer have to go to the level of detail that's in the model, but certainly it's a place to start. So moving on, we talked a little bit about, I believe I already talked about the various FAQs that Cal OSHA has published. And as you see on the slide, there's a general FAQ regarding the emergency temporary standards as a whole. And there are also some FAQs on separate subjects, such as, for example, exclusion pay under the emergency temporary standards, which we're going to go over, and also testing and vaccines, which we're going to go over in more detail. What we've put there on the slide on the right-hand side,
sorry about that.
On the right-hand side is just a listing of the very basic statement of the cleaning standards that Cal OSHA has, because that's something every employer is going to need to follow. And as I said, we've put there the very generally stated standards, but that's something that you'll want to pay attention to and make sure you follow as things open up. Can we move on? Yeah. Thank you. Now, I mentioned that there are various government agencies that have standards that apply to the situations that we're talking about here today. And so this slide begins to introduce that subject. And on here, we have the Centers for Disease Control, which is at the federal level. And there is a list of resources that the CDC has published regarding the various issues that we're talking about today, should you want to consult them or read them generally. And again, if you wish, you can contact me and I can give you the links to those things, but you can also look them up just by doing a search for CDC and then the title of the FAQ. Then at the state level, we have the California Department of Public Health. And similar to the model workplace prevention program, they've published what's called a COVID employer playbook. That's not something that you have to, it's not a model that you have to produce your own thing from. It's more a global guidance of the important points of what employers need to know as workplaces continue to open up. Then again, as I mentioned before, there are local standards. And local standards, and here I've just, these agencies don't necessarily have their own workplace safety standards like OSHA, but just to introduce the different levels of government that potentially have standards. We have Los Angeles County, which is the Los Angeles County Department of Public Health, which has a whole set of standards that apply to various issues that we're talking about. Then you have Orange County, and that is the Orange County Health Officer. And I just want to briefly mention here that there are far less standards stated specifically by the health officer than there is by the Department of Public Health for LA County. And then the city of LA has also what's called a Safer LA order. And that's something that's existed since the very beginning and has been periodically updated.
You know what, Robert, I was going to make, you know what, disregard, I'll follow up later. Okay, should we move to the next slide?
Sure, thank you.
Okay, so now our next topic is COVID screening and more. Exciting stuff.
Yeah, so go ahead if you need.
I was just going to say this is COVID screening, requesting information from employees, and what information you can or cannot disclose regarding employee information.
And I presume that this is a topic that most or all of you are interested in. And just to introduce, we have indicated with respect to the various standards, the government agency that publishes or has issued the various standards. So for example, that first point there, according to, and again, let me make sure that you understand this, the DFEH is the Department of Fair Employment and Housing, and they are the department that enforces the FEHA, the Fair Employment and Housing Act, which is your harassment, discrimination, and retaliation. So, most important point, taking temperature is allowed, and that's of your employees, of course. And then I just mentioned there that similar to the California playbook, the DFEH has published that publication that's stated there. That's the DFEH Employment Information on COVID-19. And then I just wanted to notate here that for those of you who don't have 5 or more employees, what the DFEH is saying is not necessarily all that relevant to you, except in terms of harassment, because all the provisions of the FEHA, other than harassment, apply only to employers with 5 or more employees, whereas the harassment provisions apply to every employer. Then I just state there some additional, I mentioned to you before that where there were differences among agencies that were particularly relevant, we're mentioning them here, and here's one. And that is how the employer must maintain records of those temperature checks. And then another important point that the EEOC has published is if an employee refuses to have their temperature taken, you can lawfully exclude that employee from the workplace, but they recommend that you have a discussion with them first. And that's just, in some senses, common sense, because that could potentially defuse the situation and also help you if there's ever a dispute if it later arises.
And just to clarify, the EEOC is the Equal Employment Opportunity Commission.
Thank you.
Yeah, not for you, Robert, obviously.
No, I thank you for saying that, because I just breezed by it. With these standards, as with other standards, as you see in the last bullet point, there is no specific designated end date to these standards. I would hope that at some point, either the agencies do state a date in the future that will be a specific end date, or I'm sure they, at a minimum, they will announce that these standards are lifted. Can we move on to the next one? Now, with respect to, this slide is a good example. What we've done here is we put in a lot of information so that you have the important information that you can refer back to just by looking at these slides. You don't necessarily need to read this all now. We'll hit the high points, but I just wanted to explain as to those slides that have quite a bit of written information. That is the intent. Now, with respect to various government agencies, they speak in terms of both allowed COVID testing that the employer can use at its election, and also required COVID testing. So with respect to the allowed COVID testing, it's what it states right here. And it is allowed before allowing employees to enter the workplace. And then just as a side point, I don't think many people would do this, but an antibody test is not something that is allowed. Now, I want to make a point of mentioning a potential conflict in the standards, and that's the next bullet point down. In the Cal OSHA standards, the OSHA, what OSHA states as far as returning to work, they say, as is quoted there, a negative COVID-19 test shall not be required for an employee to return to work. And as I note there, there's a potential conflict with the standards stated by the EEOC and the DFEH, which I'll get to in just a moment. And then this is an important point, the next bullet point, which is in order to be in a place where you can choose to do that testing, what the DFEH says is that testing must be a part of a comprehensive plan for reducing transmission in the workplace. And you can see, since we're talking about the DFEH, and again, that's harassment, discrimination, and retaliation, you can see the basis of them saying that, because that they're getting into a potential discrimination situation, and they're saying, okay, you need to apply this to everyone so that there is no potential discrimination. Now, the required testing. What Cal OSHA says, the standard for Cal OSHA is just an information requirement. And there is listed the information that they indicate that employers need to provide. Now, the next one down is the, if there is a potential work-related exposure to any of your employees, the next bullet point down is what the requirement is there. And with respect to at no cost, I'm going to address that a little further, just a bit further down.
Robert, wanted to ask you a quick question. I actually received this question yesterday. When an employee, and this is a little off topic, so I apologize, but when an employee reports COVID and they believe it's workplace exposure, what date would the date of injury be? Do you know?
For purposes of what?
Reporting it to workers' comp.
First of all, I don't think, given the nature of what we're talking about here, the OSHA would be at all particular about which date is selected. If you just use a common sense statement,
symptoms,
maybe when they report it, you know, or it could be anything. I don't think it's something that you need to be concerned about.
Okay, thank you.
And then Cal OSHA also talks about what to do, or what required testing there is when there is a quote unquote outbreak. And the Cal OSHA standards define what an outbreak is. I think I may have that later in the presentation, but if not, and you have a question, just like everything else, send us an email, give us a call. Can we move on to the next one? Okay, now the Cal OSHA does have some standards with respect to the workplace, if indeed the employer provides testing, and that's whether it provides it on a elective basis or a required basis. And there we list the various requirements. I'm not going to go through those in interest of time. You can see those for yourself. If any of you have a question now regarding it, send us one on the chat or afterwards, like everything else. And then again, with respect to these testing standards, there is no stated end date, and what I said before applies. This is also an important subject, and that is what can an employer request of an employee with respect to COVID-related issues. And there we've listed on that slide information requests that are allowed and information requests that are not allowed. And again, we've organized that into which agencies have what standards. And there, I'll just kind of review the ones that are allowed without getting into too much detail. As you see, the first one, which is the probably the most important one, you can ask all employees entering the workplace if they have COVID symptoms, they've tested positive, or they've been diagnosed with COVID.
Let me ask you a question on that one, Robert. Is there a time frame? Can you, because typically when I go to a store, or not store, but a doctor or a facility, they'll take your temperature and they'll ask you, have you had this within the last 2 weeks? All of these. Is that
like the other standards that we've reviewed? There is no specified end date. So the safe route is to comply with the requirements until the agencies say otherwise. But keep in mind, as to the temperature, this is allowed. It's not required.
No, I understand that. My question is rather, when you're asking the employees, when you're entering the workplace, have you had these symptoms, tested positive COVID, or were diagnosed with COVID within the last 2 weeks is the question I typically hear. I don't see that outlined here, so I'm asking.
Yeah, I understand. My recollection, and I can't say this, don't quote me on this right now, I don't remember specifically off the top of my head, but there is no, like many of the government standards that are issued, because they have been done on the fly, if you will, a lot of times there's gaps. And so sometimes the agencies don't say something specific, even as to something that immediately comes to mind as you review the general standard. And
Right.
so that all gets to my response of, best as I can recollect, there is no specification of time that you have to, or a limitation on time as to what you can ask in terms of how long before did
Right.
they. And again, probably what you could base it off of is the longest applicable period, meaning, for example, a quarantine period, because you pick the longest standard, and then that covers everything that you need to cover as an employer. And it also would be safe to say that that's a reasonable amount of time that you can request.
Okay, I've had a few questions that I've just answered privately on the chat, but I do want to ask this because I think this could potentially be a question more of our panelists have. Does the person asking if a person has had any COVID symptoms need to be an HR professional, or can the question be posed by the receptionist or a front desk person?
That is another one, just as the one we just reviewed, that there is no standard. I think to be safe, if you will, I would have that be a management person, because there are because you're thinking about confidentiality and things like that. And although this isn't very intrusive.
Right. Particularly in order to track the temperature when they're taking it and all of that, I know that has to be maintained confidentially, which is why we would recommend a person of management level to do these questions and temperature taking, et cetera. Would you agree?
Yeah, and also adding to that, it would probably be a good idea to have one specific person that does it, because that just gives a sense of greater confidentiality rather than having random people all getting their information.
Correct. Okay, thank you, Robert.
Sure. And so the other one I want to, that may be important to some of you, as to people who employees who you might think or might believe are potentially taking advantage of the COVID specific time off. There you see the next standard, or the next information that the agencies give, that if an employer suspects that an absence is for a reason other than COVID, you can ask that employee specifically why they were absent. And I would recommend that you have a solid basis for making that inquiry. And then the next one goes to something we'll talk about a little further later, which is travel. I don't know how many of you have employees that travel either domestically or internationally. But with respect to that subject, employers can request a report of travel to high, and this is when this applies even when they are off. So even those of you who don't have employees who travel for work, with respect to the
Vacations,
time off that
etc.
they take,
This would apply to vacations, personal time off, weekend getaways, etc.
correct, correct. And so, and the ones that you can ask, or you can just ask them, well, there's a number of ways you can do this, but the ones that you want to limit your inquiries to are those that are designated as high risk. And the CDC has a list of specific places that are high risk. And those are the ones that you can ask about. And that the point of some of the others there is you can ask prospectively or retrospectively as to those high risk areas. And here's another important one that comes next. If indeed you wish to, you can require that the employee have or obtain and provide a healthcare provider certification of fitness to return to work. On that subject, however, there is information in the various guidances or requirements that it may be during this pandemic time that it is impractical for requiring this in certain situations because the employees might not be able to expeditiously get that certification of fitness to return to work. So the guidances ask employers to exercise their judgment in what they are requiring in that regard. Now, going on to the not allowed. And here is what this first bullet point deals with is, again, a discrimination issue, and specifically disability discrimination. And so the requirement itself is an employer cannot ask an employee whether they have any underlying conditions that may place them at high risk for severe illness. And that is a term of art. And what I mean by that is there is a definition of and a listing of the underlying conditions that are considered to place someone at high risk for severe illness from COVID. And we're going to I think that's in a later slide. The other thing also, what we're going to discuss a little bit later is the considerations with respect to discrimination, disability discrimination, and so forth. And then here they're addressing a privacy issue, and that's you can't ask the employee if they have family members or others that they come into contact with necessarily, if they have had a positive COVID test or symptoms. So we can move on.
We have a question that I think might be relevant to the group. The question is, I have an employee who's going out of state this weekend for personal reasons. Can we ask her to take a COVID test upon return to work?
You can have her take a COVID test, whether she's going somewhere or not. The issue is it has to be, well, and this is what they may be asking. They may be saying, okay, we don't want to do the whole workforce, but we want to test this person. And does this person going to Arizona justify doing only that person? If that's what the question is, unfortunately, I'd have to say maybe, maybe not.
Slippery slope, right?
It is, and there's always a risk to these things. The way I would analyze it, off the top of my head is there some data in Arizona that in any way suggests that there's more cases, there's been a spike, and those types of things, because that would be the information or the evidence, if you will, that you could rely on to justify that kind of situation.
And additionally, wouldn't it be a consideration to make it a blanket policy that any employees that you know of that are going to be out of town, be it Arizona or whatever the case may be, must have a COVID test upon returning to work?
That would be certainly recommended, because that's the best way to protect against discrimination. Let me talk about discrimination there, what that would look like.
Okay.
What I mean is, it's not discrimination on the basis of Arizona, even though
Right.
who knows what we all think. But what it is essentially a fortuity, is what it would be, but it could be interpreted other ways if, for example, that person who went to Arizona is in a protected category under the FEHA, disability, gender, race, what have you, and you didn't test other people of other, whatever the protected category is, that's where there would be an opportunity for someone to try to make a claim of discrimination. That's how it would play out potentially.
So this is, this is where what you do for one, you do for all rule kind of kicks in, correct?
That's exactly right. So you don't necessarily need to say, okay, we're doing one employee, we need to do every employee. You can keep it in categories, and I don't mean protected categories, but I mean, okay, anyone who's traveling out of state will get tested upon return.
Exactly.
But
right.
You don't have to necessarily do domestic or international. Although I would say, if you're doing international, it would probably behoove you to do it, particularly if it's a high-risk area.
Correct. Okay, wonderful. Thank you.
Okay, very briefly, with respect to some other aspects of what employers can require and not require. Very briefly, with respect to personal protective equipment, this is probably common sense. You may already know this. You can require the employees to wear that protective equipment, except in a very, not that you need to give someone an exception, but if you have someone who requires, in a protected category, who requires additional protective equipment, you as an employer need to provide that. And the example here is, if someone is wheelchair bound, they have an allergy to latex, the employer would be technically responsible for supplying those types of gloves for the employee to use in the workplace. One quick thing on this before I proceed, I'll mention it generally first. With respect to reasonable accommodations for disability, and some of this may already be common knowledge, but I just want to make sure if it's not for everybody. There is an exception to the duty to provide, there are two exceptions actually, to the duty to provide reasonable accommodations. One of those is if it's an undue hardship, and the other one is if providing the reasonable accommodation would result in health or safety risks in the workplace as to others in the workplace. I'll just briefly, without getting into detail, I'll just mention that undue hardship is difficult to show. It's a high burden. But certainly, at least for the foreseeable future, the health and safety exception would at least sometimes be legitimate. And so, disclosures to other employees, this is another important one. And some of you may already have certain operations where the disclosures are required. Some of you may not, but what you need to know is if indeed someone tests positive, or the other standards for COVID, the subject to a quarantine order and so forth, what the employer may do is that they may notify others of that they have had some exposure to an employee who has COVID, which again is there's specific standards as to what constitutes has COVID, or and that's diagnosed with, et cetera, and so forth. And then, as I mentioned before, subject to quarantine. If you do that, you need to be anonymous. You need to be generic, no names or other identifying information of that person who has COVID. And I'll just mention too, there are definitions with respect to exposure. When does a employee who doesn't have COVID have an exposure to an employee who has COVID? There are very specific definitions with respect to that. And those, if I'm not mistaken, as I sit here right now, are in the OSHA standards, and that would be specifically in that one regulation that I mentioned before, which is the 8 Cal Code Regs 3205. Can you go back for just one moment?
Sorry, I'm
This
sure
is
you're
an
happy this
important
morning.
one, the
I
last one.
apologize.
Leave any health issues out of any information that's provided or any discussion with any other employee. You know, it's blanket, it's absolute. So just remember that.
Right, and that's not specific only to COVID situation or the pandemic. That is across the board always.
Yeah, and also think through what constitutes health information or health matters now that we have all this unprecedented stuff. So if it's anything that relates to COVID, think about it and use your best judgment. Or, you know, you can look at the regulation closer, or call your HR professional, call your employment attorney, and they can expand on that further for you. Next one.
Okay, just to let you know, Robert, we're at the halfway mark, so picking up the pace a little
Okay,
bit.
let's pick it up. Now, there are specific local standards, and that's for that are issued by the Los Angeles Department of Public Health. They also have some FAQs. I'm not going to review those because they're stated here, and not all of you have businesses in LA. So let's go on to the next one.
Okay, we're going to hit exclusions from workplace and return to work after exclusion and exclusion pay.
And right, so generally speaking, there are certain circumstances under which you can say, employee, you can't come into work for this period of time. Then there are, in certain cases, requirements where you have to pay that person under that standard for the time that they are excluded. And there are also requirements for an employee who had COVID to return to the workplace. And here I've just listed the standards, and I've put in italics the keyword, and that's, as you can see there, it's should, can, may, which is a permissive rather than a requirement. And that's when they have symptoms. If you go on to when they have a positive test, again, one standard says should isolate per local isolation orders and therefore be excluded. The DFEH says keep a record of that, and the LA Department of Public Health states it as a requirement. And as you can see, these are the different circumstances that when someone has COVID: symptoms, positive test, close contacts, right? And so there you see the exclusion standards for close contacts. Now, it says, the title to this says, other than Cal OSHA, because Cal OSHA has a much more specific, detailed, and exacting standard. So let's move on to that one, I think, which is on the next slide, I think. Can you go back one, please? Yes, right here. Here's just some additional information with respect to what to consider when determining whether you're going to exclude someone from the workplace. I just wanted to explain that.
Move forward.
Yes, please. Okay, so here are the Cal OSHA, both the standards for exclusion and the standards for when an employee can return to work. As I mentioned, these are detailed standards. So one of the things, and look, let's be realistic here. Not all employers have the ability, whether that's from a resources standpoint or a workforce standpoint, to completely study and understand and enforce all these requirements. And that is why at least Cal OSHA has some level of reasonableness with the good faith standard. So again, with respect to the exclusion and return to work standards, have one of these, the statement of the standards, and say, someone comes in, yep, yeah, we have these standards and we try to do whatever we can. So that's just a reminder of that. With respect to the COVID standards, they divide their standards as to COVID cases and COVID exposures. Right there, you have on your slide, what is a COVID case? And that's any one of those three possible circumstances. And then also, what is a COVID exposure? And that's important to know because the standards that are applicable in each situation are slightly different.
We do have a question I think might benefit the group. And it says, are we required to do anything for our employees as they do not check into an office? Sounds like they work their sales or something. They drive straight to their assigned accounts. Most client offices are closed when they arrive. Some have their own staff taking everyone who enters temperatures. So I think we're talking about employees that are predominantly remote and or sorry, they had just clarified. It's a service or janitorial. So they don't check into an office or a work site initially, they're just dispersed to the appropriate accounts they are servicing. So can you, okay.
Should I answer now?
Yes, please.
Okay. The rule of thumb to keep in mind with respect to all of the things we're discussing today is we're talking about the workplace. And that's when you need to think about these standards. If there's anything outside of the workplace, it's not covered by these standards. So, for example, to use use an example that is potentially between someone who works exclusively at home and workplace, but instead goes to client sites, the responsibility with respect to those people who visit the client sites is the client site.
Okay.
Just like if you have people coming into your workplace that are not employees, that's going to be something that you are charged with the responsibility for.
Okay, and then we have another one. What is the difference between isolate and quarantine?
If you, different agencies have isolation and quarantine standards. For example, the LA Department of Public Health has some specific isolation and quarantine standards that are published. I believe that either the California Department of Public Health or the California government, if you will, has also isolation and quarantine standards. And you can look at those publications for a reference as to figuring out what they are. And I believe actually I have a slide that's coming up. And if it's not in the slide, I believe I have it in my own outline where you can find isolation and quarantine standards. So hold one second.
But I'm so sorry. Would you say that the term is interchangeable, generally speaking?
Absolutely not.
No. Okay. Good to know.
Yep.
Okay.
And by the way, it's a appropriate question. It's in this context because that's exactly the kinds of thing it is. I'll call it analogous. So COVID case is your isolation. COVID exposure is your quarantine, generally speaking.
Okay.
So let's go to the next one. And I will keep in mind that question about all the different isolation and quarantine standards as we move on. Okay, so now return to work. Again, split up between COVID cases and COVID exposures. These are, again, since we're trying to move through as quickly as we can, I will, and the standards are stated at least somewhat in detail here. I won't do a read through of these things. You can read through them yourselves. And if you do have a question as to what's stated there, put it in the chat, give us a call, give us an email, and we'd be happy to expand on that. And so just to orient you, with respect to COVID cases, the standards are different if you have somebody with COVID symptoms and somebody who tested positive but never developed symptoms. And then again, this is important. This is a very important point, which I want to highlight. When we talk about COVID exposures, with respect to these standards, we're talking about exposures in the workplace, not if they are home and they were exposed to their grandmother that had COVID. And then as I write there, subject to the exceptions, or excuse me, excluded for 14 days after last known exposure to COVID case. Let me make a point there. This standard is with respect to the workplace, and the 14 days is, generally speaking, the standard or what's required under the quarantine orders. And so again, this relates to COVID exposure. And as a practical matter, you're not going to necessarily need to differentiate between, well, let me back up. For purposes of exclusion, you need to determine whether it was in the workplace. You are still obviously concerned with exposures outside of the workplace, and that's when the general quarantine standards apply, and you can ask questions pursuant to what we discussed before and the other more detailed situations. Now, there are exceptions to the excluding folks for 14 days, and let's move on to the next one.
We have a couple of questions. So one is, if test results are negative, do they still need to remain at home for 10 days?
If they have symptoms.
What I thought.
Yeah,
okay.
so under a quarantine order, it will state, as you'll see if you look at one, is if they experience symptoms, and they list out the examples of specifically what those symptoms are, what they are required to do for quarantine, and therefore you can enforce, if you will, in your workplace, and you should.
Okay, great.
Okay, now I do want to explain something here, and then maybe not go into detail with respect to all of them anyway. So here, I've listed the exceptions in both the situations of a COVID case and COVID exposure, and they're narrow because, as you can see there, one of them is if there's an opportunity for the employee to be assigned somewhere where they don't have contact, and that's not necessarily just to have them work at home, but that's obviously it's about exclusion from the workplace. So we are talking about something other than having them work at home, and you may have an area of your office that is separated from everyone else or something of that sort. So that's what it would potentially apply to. And then this one is very narrow because it is a special request to Cal OSHA to have them excluded, because having them excluded would be a threat to health and safety, and that would be in your healthcare type fields. Now, the next one is what I call an override. It's not an exception. It's something that applies if this circumstance is present. Then you don't pay attention to anything that they say in the Cal OSHA standards. You do what's here, and that is you can't basically you don't look at just the Cal OSHA standards, but in the narrow circumstance where a local or state order to isolate is different or more, it involves more, then you have to follow that applicable local. It's not going to be a state one, that's because this is the agency that puts out the standards for this. But if you have a local one that applies, and for some reason, I don't think it's going to happen much at all, or if any, but you need to follow that higher standard, if you will, or additional standard out of that local order. And then here's where previously I mentioned a potential conflict. And as we discussed before, OSHA has stated in its emergency temporary standards that as far as a return from work, a negative COVID test shall not be required for an employee to return to work, whereas the EEOC and the DEFH specifically state that employers can require a COVID test before allowing employees to enter the workplace. I don't have an answer for you as I sit here as to what you should do, or if you are someone who wants to test somebody when they come back to the workplace. But I am working on speaking with folks who can have a definitive word on that. We're ready to move on to the next one.
So again, we're at the 30-minute mark.
Okay, so let me just briefly, exclusion pay and benefits. Again, this is only for workplace COVID exposure. They are a whole set of complex provisions. The main provisions are listed there in the bullet points. Take a review of those to see if it applies to you or your situations. If you have questions, let us know.
Travel.
This one we'll cover very briefly, actually, very briefly. So there's the CDC travel guidance that applies and the California Department of Public Health travel advisory that applies. And they are separated into categories. You have domestic, which breaks down to fully vaccinated and not vaccinated, international, same thing. And then the only standard for the CDP, the California Department of Public Health, is when it's outgoing vaccinated. There's some more information on the standards. This is a not frequently applied situation, so we're not going to spend time on it, but there is information there, as well as those references that you can find that these agencies publish, that you can read for yourself, and then again ask us questions. And we can go to the next one. Okay, so here's another big subject, and it's as it states there, and these are inextricably intertwined, these two things. So here are some specific standards that are stated by the agencies that deal with discrimination, harassment, and retaliation. That's at the federal level, the EEOC, at the state level, the DFEH. So with respect to, when we say job only at workplace, that means they don't work from home, they can't work from home, they have to come into the workplace. A warehouse, and you have a warehouse worker, just as one example. But they are a high risk. What the EEOC says, there may be accommodations for, and when I say high risk, that's the same high risk that I was referring to before, for which there are definitions. And then they list their, well, we've listed their examples, but there are other examples of the types of things that you may be able to give to or institute to have accommodations for someone who is at high risk. Because again, I mean, if you have a high risk employee, you've got different things to think about. And then when we're dealing with mental illness, what we're talking about is not entirely pre-existing. It's going to be pre-existing in a sense, and that is if the employee has mental illness that's exacerbated by the pandemic. And then there are different accommodations that you could possibly make. And that's the same as the accommodations that you might make in a non-pandemic situation. And then here's one where you are not required to provide accommodations, And that's when, oh, I have a high risk, I have a member of the family at home or someone who I live with that is at high risk. You don't need to provide them with accommodations. Here's a situation that comes up fairly frequently, and that is for the people. And by the way, the global categories, or the wider categories of people who are at high risk, are the folks who are age 65 and older and pregnant. And I'm not sure as I sit here whether those are included in the definitions, but these are just categorically people who are at high risk. And with respect to accommodations for these folks, I list the different agencies' statements regarding accommodations. And when I say EEOC and I refer to that bullet point, that is a publication that you can find, and that will give you information on this subject. And there is these bullet points have the other information that give the broad strokes that'll orient you to what you need to think about. Here we are. Here are the definitions. And this is the definitions that apply to people who have underlying the accommodations that apply to, and these are, I misspoke, these are not the definitions of the conditions that will put someone at high risk, but rather a statement of the standards that apply to the category of underlying health conditions and the category of age. And age, you might have this situation come up in several of your workplaces, and important to note that age is not a disability, because all we're concerned about here is disability discrimination. And so age is not a disability, so employers are not required to accommodate based on age alone, but you need to consider what's stated there in the next bullet point. And I'll also mention, some of you might think, what about age discrimination? Well, this only speaks to disability. So just because they're old it's not a disability that you have to consider as putting them at high risk for the purposes of providing reasonable accommodations. However, just like our Arizona state example, there is potentially something where if you decided to provide reasonable accommodations to some folks that are younger, but not as to folks that are 65 or over, then you might have a different type of discrimination on your hands. This just talks about, and this is stated pretty specifically, and that is what documentation an employer can seek, and it's pretty straightforward. And then a general note at the end, as far as defining disabilities and determining employees within a category that need to be treated similarly, there is a rule of thumb stated there, which is disabilities are always judged on a specific, circumstance-specific, fact-specific, situation-specific basis. But the rule of thumb is all similarly situated employees must be treated similarly.
Okay, vaccination issues and employer vaccination policy. We're going to talk about the issues, but I wanted to let you know that we will be providing on the follow-up email a copy of a sample vaccination policy.
Okay, these are probably important to a lot of you, I'm assuming. And then the main rule is stated up at the top, and that is, subject to limited exceptions, you can require employees to be vaccinated for them to come into the workplace. And I just mentioned there the CDC publication, which provides some more detailed information about vaccination. But again, the general rule still applies, subject to these exceptions. And although there are certain circumstances that need to be present for the employers to have that vaccination policy. And I list them just right out there in 1, 2, 3. 3 is on the next slide. And if you just go to the last one for a moment.
The previous slide.
Yes, please. With respect to the EEOC and DFEH, they are the ones who state the following, or the 3 conditions that I'm referring to. And the first one there is that the employer does not discriminate against or harass any employees based on a protected characteristic. That's what we have talked about, and that's what you do anyway. The next one is, not only disability, but also, and this is a big question that I've heard a lot of, or I've received a lot of questions on, and that is, what is a sincerely held religious belief? And so what number 2 is saying is that you have to consider, for a vaccination program, you have to consider exceptions for reasonable accommodations for disability, or sincerely held religious beliefs. And let me be more specific. Reasonable accommodations as to them being vaccinated before they come into the workplace. And like I say there, all disability standards and requirements apply in the specific situation that we're dealing with here. And then I list there that a possible vaccine-related accommodation is accommodating them by, okay, you don't have to come into the workplace or be vaccinated in order to come into the workplace, but you're going to have to work from home if that's something that you want to allow them to do.
We have a question that I think is pertinent. How do we prove if employee stated its religion/medical and don't want to get the vaccine?
I think that's spoken to on the next slide. If not, I have it in my outline. There it is. Religious beliefs or practice. And let me see, I can't remember if it just covers that specific question. But the idea is to, as it states in the first bullet point, eliminate the conflict between the particular belief within that religion and the vaccination requirement. So let's just say, I don't know if this applies to any religion, but we don't believe in vaccines or what have you. I'm just trying to come up with an example. But then listed in the next bullet point is the possible accommodations for people who, based on a sincerely held religious belief, don't refuse to be vaccinated or don't want to get vaccinated. And then there is some exceptions to any requirement for reasonable accommodations. And indeed, it looks like, I don't know if it's stated on the next slide, but I'm thinking not, but there are specific standards with respect to how to interpret and apply specific, sincerely held religious beliefs. And if you email us, I don't seem to have listed it specifically in my outline. Just a moment.
Any questions that we've had that we haven't completely answered here, we will follow up with on an individual basis. So Robert, let's go ahead and move on and we can address this.
But what I do know is that there are specific requirements and standards that speak to that issue. Okay. And then we have the employer not retaliating against anyone for engaging in protected activity. Will you go back one, please? Yeah, so that's not actually number 4. Number 3 is, because remember before we talked about 3 conditions. for having a vaccination, a requirement to be vaccinated. For it's just a typographical error, and go on to the next slide, please.
Okay, Robert, we do need to move along because we're at the 20-minute mark, actually short of. So
we're at the end, are we not?
no, we have the California supplemental sick leave, which
right.
I know
Okay.
that everybody is very interested in. So if we can, we're going to just go ahead and skip the next few slides on vaccination. Please do review this because there's some important things, specifically right here where it says you cannot, just because an employee doesn't feel safe taking the vaccination, that's not a reason. It's not a protected category or characteristics, et cetera. So we're going to move on to the California supplemental sick leave.
Evelyn, do folks has the chart that I prepared?
No, it's going to be sent out. So if you could just cover the major bullets.
Sure.
And then again, we'll include the chart with all of the information we send with our follow-up email, normally within 1 to 2 days after the webinar.
Very well. The most important point, I think, with respect to sick leave is the scope of employers that are the new sick leave law applies to, and that is only to employers that have 25 or more employees. So those of you who don't have that, then this is not something that you need to pay attention to. Very briefly, we had the FFCRA before, and we also had the 2020 California paid sick leave. FFCRA has expired, so that is not required anymore, although you can, as the act that was, I don't remember the name of it off the top of my head, but there was the act that came out after it expired that said you can, as an employer, you can choose to, and you can still get tax credits
for it. It was optional versus.
But it's optional. And that applies to family leave as well.
We have a question. Is this 25 or more part-time or full-time employees, or does employment status not matter? It's 25 employees.
The latter.
Full-time employees.
Yeah, it's not like full-time equivalents or anything like that.
Okay, so it's 25 or more full-time employees.
And so, what I was talking about was, so we have those, and those are expired. This is different. This one is, and how I keep it straight in my head is I call it the 2021 California supplemental paid sick leave law. And remember, and you may or may not remember actually, but that 2020 law was narrow. And so a lot of, probably most of you or all of you, it didn't apply to. But this one is significantly wider because it expands it to employers of all types that have 25 or more employees. Briefly, with respect to the dates, it was in fact enacted on March 29th, a month ago or so, a month and a half, but it was designated as retroactive to January 1st. And what that means is an employee can request that they took strike that. If an employee had taken some paid time off that was for a qualifying reason under the sick paid leave law, and I'll get to that in a moment, then that employee can request that that the employer use the California supplemental paid sick leave instead of whatever was applied to the time off that they took.
So retroactively, they can request the supplemental sick leave.
A nuance to that, the law actually says that the employee needs to request. So as a technical matter, it's not don't ask, don't tell, but if they don't ask and you don't tell them, then your requirement doesn't arise technically.
Okay.
But a nuance on the flip side, I guess I'll say, is, okay, do you need to then also then replace, and maybe you're doing that effectively, I'd have to think that through, replace the day off for the PTO? And the answer is there is no a specific answer in the laws, but the
That's the best
thinking,
practice.
yeah.
Yeah, and I've actually had a few calls in regards to that. We do have a question, and it says, I thought Governor Newsom extended the FFCRA as of 3/31/21 until 9/30/21. And I think you're talking about the COVID sick leave. Remember as part of the FFCRA, there was a COVID sick leave that was allowed, right?
That may be, but I guess I don't know off the top of my head because it's so narrow. Don't have any. I have few, if any, clients that applies to. I don't want to misstate. I believe that sounds right, but I just don't know as I sit here, and so we can certainly answer that. I can certainly answer that question in more detail even than I could tell you here.
Right.
Yeah.
Okay, so we can address that. We'll get a report, as we do always, Robert, that we can address all of these questions separately. And I do want to assure everybody that the chart that we will be providing regarding the California supplemental sick leave is very thorough and detailed, and it's very easy to read, and will be extremely helpful once you receive it to understand what is required.
And just to give you a sense, the way the chart is prepared is we list the subject of the particular provision of the law, such as, okay, what are the effective dates? What are the qualifying reasons? How much amount of leave, and so forth. And then in the next column over, it talks about what the requirement is specifically. And then there's another column for what I call notes, which are further things that you might want to consider or might apply to and might not. So we've talked about the retroactive in a very summary sense. But again, if you have specific questions, let us know. Now, with respect to the qualifying reasons, is something we probably should introduce now. And they are separated into three categories. One is caring for yourself, one is caring for a family member, and one is for vaccine-related COVID sickness. And so the caring for yourself, that is, there are three circumstances. First one is the employee is subject to a quarantine or isolation period per any applicable health official order or guideline. The employee has been advised by a healthcare provider to quarantine, or the employee is experiencing COVID-19 symptoms and seeking a medical diagnosis. That roughly correlates, at least roughly, and it may correlate exactly to most health officials' quarantine standards.
Robert, there is a question, and I don't know if you can answer this. I don't know off the top of my head, but it says, is there a tax break on the sick leave?
No, it's
No.
California after all.
Okay.
Yeah.
Okay.
So,
right.
So the next category, the second category, is caring for a family member. And there are two circumstances. And that is when an employee is caring for a family member who is subject to a quarantine or isolation order, or it's basically the three circumstances that we went over for self, but just insert caring for a family member under those circumstances. And just briefly, it's subject to a quarantine or isolation period, or has been advised by a healthcare provider to quarantine, or and then slightly different is the employee is caring for a child whose school or place of care is closed or unavailable due to COVID on the premises. So that's got some specificity to it. And then finally, vaccine related. This is just with respect to actually getting the vaccine, the time for getting the vaccine, and also specifically vaccine time off when they have vaccine related symptoms or side effects, if you will. Amount of leave.
I'm sorry. Robert, we do have a question, and we're down to just under 10 minutes. I was under the impression 2021 California supplemental sick leave was combined with the FFCRA time. Should this be a separate category in payroll?
There's some complicated rules with respect to that I couldn't even begin to fit in here.
Okay.
And when I say this, what I mean is wage statement requirements and the calculate or how it should be listed on the wage statements for certain types of people, right, like in that situation.
Okay.
But we can certainly get that information to that person.
Okay.
We want to make sure to cover the broad strokes, most important broad stroke here. And then, so the amount of leave, actually, I'm not going to get into the specifics here because there are some different things that you need to think through, but I'll just cover the ones that you don't need to think through. And that is for full-time employees, it's 80 hours, simple. For part-time employees, and that's anything other than full-time. And by the way, full-time is defined in the statute. I'll just tell you, it's considered by the employer to be full-time or scheduled for an average of 40 hours per week in 2 weeks, leading to the commencement of leave. And that's just an example of how it starts getting into some convoluted things. And that's mild compared to some of these others. But again, we can walk you through it. We're happy to do that. And again, I'll remind you that don't be concerned if we don't get to these, the broad strokes even, because I think once you look at this chart, it's going to answer a lot of your questions, and it's going to it's going to serve for you to refer back to whenever a question arises.
It is very comprehensive, very comprehensive. Too much to have put on the PowerPoint, but definitely something we will send out.
Okay, so then amount of leave, back to amount of leave for a moment. Part-time employees are anything other than the definition of full-time employees. And it gets into categories of a normal week, like a recurring schedule, recurring amount of hours each week for a part-time person, and then a variable schedule. And then the variable schedule is what gets into the real machinations. But the normal weekly schedule is it is simple, and that is the sick leave amount for someone who has the same amount of hours a week repetitively equals those normally scheduled amount of hours that they have in 2 weeks. So they work 20 hours a week, they get 40, and so forth with respect to that calculation. Variable, there is an explanation of what rules apply for variable part-time employees with variable work schedules, and the standards are right there. They're straightforward. Well, maybe not straightforward, but a clear statement of what they are anyway.
All right, we have exactly 6 minutes left. Do we want to cover hero hazard pay quickly?
Well, I can just state it very quickly because it's so narrow. And actually the things that you might be interested in are stated there on, I think it's one slide, because it's very narrow. It's limited to grocery and pharmacy, and in some cases some retail. It is instituted, if you will, by mostly by counties, but in some cases cities. And it only applies, all of them apply to a number of employees no less than 300. Some of them the threshold is 500. And then they mandate a wage, a certain amount of dollars per hour that you have to pay higher during the pandemic and such. So that's enough to cover for that. More important to start walking through some more of the sick leave. As much as
we're down to 5 minutes, so let's do 3 minutes and then we can wrap up.
Okay. Unless we want, do we have questions?
I don't have any questions right now on, those that are of you that are participating, if you have any questions on the sick leave, please ask them now.
Okay, so carrying on, we did talk about, I alluded to the wage statement requirement, and that is simply the time used and the time available must be reflected on the wage statement, same as other sick leave. then let's see, we have, some of you, this is a question that came up, or I thought came up, but maybe it turned into something else. And that is, on the chart, you'll see some information regarding how does the 2021 sick leave interact with other sick leave laws. Most importantly, it is like, so for example, you take the California 2020 law. This is additional. And what that means in this circumstance is that any considerations of how much may have been given or how much was available for the 2020 law isn't in consideration here. You just look at the 2021 California sick leave law. And then that's the same with respect to the state mandated 3 days or whatever it is now, sick leave that is not COVID specific. And then the interaction with local COVID paid sick leave entitlements or your company policy for paid time off, that gets more, a little more involved than we can cover in a couple of minutes, but it's there on the chart. The pay rate is the highest of 4 specified potential pay rates. Those 4 pay rates are stated, those 4 possibilities are on your chart, and the one that you pick is the one that comes out as the highest.
Okay, Robert, I'm going to interrupt you because we have 3 questions in 2 minutes. So let's see if we can knock these out. First one is, since we have the choice to still offer extended FFCRA, can we use that for the tax break rather than the 2021 California supplemental sick?
And I guess that I would ask a follow-up question, which would be, when you say instead of, are you saying that you would have it be FFCRA, like you would designate it as, FFCRA voluntary and not subtract from the COVID balance, or?
That's what I'm understanding myself.
Okay, then yes.
Okay.
Because look, that only benefits the employee.
Yeah. Okay.
In a way, because they're getting additional time.
Right. And then the next question is, if we have 26 mostly part-time employees and several are out due to COVID exposure at the workplace, do we need to pay them their normal wage for the 2-week time frame or the 10 days? Please correct me if I'm wrong, Robert, but I would assume that they would pay their average pay rate, the average hours they would work as part-time employees, not the 10 hour or not the 10 days. Is that correct?
Yeah, because the amount of leave required under the 2021 law for people who have a normal recurring amount, the same amount of hours recurring per week, they only get that number of hours per week times 2.
Okay, and then the last one, and then we'll wrap up. I apologize if this was answered, but the California supplemental sick hour balances, do they need to be listed on the check stubs every pay period? I have not heard that they have to be listed on the check stub. I know California law sick leave, the traditional sick leave prior to the pandemic, needs to be on the check stubs, but do the COVID hours need to be checked?
Yeah, we talked about that. I breezed through it kind of quickly,
Okay.
But the answer is yes. What the information I need to provide to the one person who asked the question is, okay, what if we have, how do we list it if it's in 2 different categories, or whatever that question was. Wrap up, or another question?
Nope, wrap up. So we will, again, thank you, ladies and gentlemen, for participating today. We value your time and we appreciate your attendance. It's our goal to provide as much information and content and help you travel through the maze that is employment law in California. Again, we will send out the recording, the presentation, and any additional documents we mentioned throughout the presentation to you via email within the next 1 to 2 business days. Robert and I are always available to assist with any questions you have, and we look forward to our next webinar that should be on or about July, August of this year. Thank you again, and you all have a wonderful rest of your day.